Nephrology Specialist PC versus MMDS Inc. et al., 45C01, 1212 PL 129. For the record, would everyone identify themselves and who they're representing?
Good afternoon, Your Honor. It's David Lake for the plaintiff nephrology specialist.
Okay.
Hanson Williams, Judge, on behalf of Jeff White and White Consultants.
Okay.
Scott Gainey on behalf of Northwest Indiana Medical Properties Partnership and MMDS Inc.
Okay.
Carrie Conner on behalf of Jeff Whiteman, Whiteman Associates, and MMDS.
All right.
Your Honor, Red Talker on behalf of Dr. David Ashker.
Okay. How about motion here for the temporary admission of, or verified petition for a temporary admission of Christian Neiman?
Your Honor, that is a colleague of Amanda Metz, who represented a third party to be in this case.
All right.
He's not here today.
She's out, he's going to be in.
She's in-house and he stepped in.
Okay, all right, thanks. All right, we're here on motion to lift to stay.
That's correct, Your Honor.
We want to argue it?
Yes.
Okay.
Your Honor, I brought a very brief handout. May I push to the minute?
Sure.
About a year ago, August last year, in fact, we were here on a motion to stay the case by the defendants, anticipating a federal indictment. At that time, we hadn't yet gotten to the point of a federal indictment. A lot has changed since then. An indictment has come down against Mr. Whiteman and a few others. An indictment has come down against Mr. Whiteman. Then there was a superseding indictment. And then just recently a second superseding indictment is now against Mr. Whiteman and a few others. At this point, Your Honor, I think it's appropriate to lift the stay of the civil case, given that the civil and criminal cases primarily don't overlap, which was the assumption that we had made in entering the stay last year. For the ease of the court, Your Honor, if you turn to page 2 of the handout, I provided the standard that we employ to judge whether stay is appropriate to be maintained in the case. And as Your Honor sees, granting the stay is an exception. There's always an exception, not the rule. Courts have laid out, including Indiana courts, a number of factors that we weigh in order to determine whether the stay should be maintained, Your Honor. There on page 3, we looked at factor number 1. And this is the extent to which there's similarity, Your Honor, between the criminal and civil cases. What I've done is summarize the superseding indictment. The second superseding indictment. There's 36 counts in that indictment, Your Honor. And if you follow me through the handout here, there's 8 counts of bank fraud against Mr. Jack Whiteman. And this is related to transfers and then use, the alleged transfers and use of monies that were in personal accounts of 2 physicians. That's not a claim that we've made in this particular civil case. There's 1 count of bank fraud involving Fifth Third Bank, where Mr. Whiteman is charged with omitting the fact that he owed money to the IRS. Again, that's not a count or a claim that NSPC has made in this case, the civil case. Then there's 1 count of concealing assets in this Chapter 11 bankruptcy. Again, that's not a claim that NSPC has made in this case. Then there's 1 count of conspiracy to conceal assets that involves Mr. Whiteman and Mr. James Schaefer and Ari Whiteman, Mr. Whiteman's son, related to concealing assets to defraud Mr. Whiteman's creditors. And again, that's not a factual claim that NSPC has pursued in this case. As you go on through the second superseding indictment, Your Honor, this is on page 4 of our handout. There's 14 counts that charge Mr. Whiteman with concealing assets related to a variety of activity. And again, this is not factual conduct that NSPC has alleged in pursuing its civil claims against Mr. Whiteman or his companies. Then there's 2 counts that charge Mr. Whiteman and his son with money laundering, which is again not 2 claims that NSPC has pursued against Mr. Whiteman or his companies in this civil case. Then in the criminal case, there's 4 counts that charge Mr. Whiteman and Mr. William Burkhall with wire fraud. Those 4 counts are not counts, not claims that we've made in this civil case. And then there's 5 counts that charge Mr. Whiteman with filing false tax returns. And we've not made those claims in this case, Your Honor, either. The Indiana Supreme Court has indicated that as one of the factors that Your Honor can use in its discretion to weigh whether a stay should be maintained is whether the cases overlap. I think if we review the second superseding indictment, it's pretty clear that these things aren't the subject of what we've alleged here. You'll recall, Your Honor, here, the allegation is that Mr. Whiteman, through his company, MMDS, and Whiteman Associates, either misappropriated or mismanaged monies that he contractually had obligations to manage the right way for our company. It doesn't concern the personal accounts of these other 2 business positions. It concerns the business account that NSBC, the business accounts that NSBC has. So I think factor 1, Your Honor, weighs against any further stay in the case. If you turn to page 5, Your Honor, the other factor that the courts weigh is the interest of the plaintiff. What's the interest of the plaintiff in proceeding expeditiously with the litigation? There's a constitutional concept of proceeding judiciously and expeditiously in a civil case. And the Indian courts, including the Indian federal courts, have said that unless there's some sort of showing of undue prejudice to the defendant, there's no reason why NSBC, the plaintiff in this case, shouldn't expeditiously proceed to pursue the claim. We're about at the 3-year mark, Your Honor. The case, I think, was filed in 2012, December 2012. The third amended complaint, which is the operative pleading, was filed in 2013. The case has some age to it. The stay itself has been in effect for a year. I think at this point, since the 2 pleadings don't overlap, the third amended complaint and the second superseding indictment, that we should proceed on with the trial in the civil case. If Your Honor will turn the page on factor 3, another factor that the courts consider in assessing the stay, we also look at Mr. Whiteman's interest. And were this a situation, Your Honor, where the cases significantly overlapped, I would think that this would be a factor that would weigh heavily in favor of Mr. Whiteman. But that's not the situation. And the courts have made it clear that it's not a problem to place litigants in the situation of having to choose between their Fifth Amendment rights in the civil case and deal with any adverse inferences. I think that concerns even less now that we have the second superseding indictment, Your Honor, because the cases are not overlapping in that respect. When we were here last August, Your Honor, for the defendant's application for a stay, they based the request for a stay on a couple things. And there's 2 quotes here on page 6 from the transcript of that hearing, Your Honor. Obviously, we didn't have an indictment back at that time, but they said, Your Honor, there would be virtually no question there's a parallel criminal proceeding. Well, that hasn't panned out, Your Honor. We've got the second superseding indictment. There is not a parallel criminal proceeding. That criminal proceeding does concern other conduct. 2, what the defendants represented to Your Honor was that the stay would be here for a short period of time. That they were not trying to postpone this matter forever or for a huge period of time. And they were asking for a short continuance. At this time, Your Honor, we're over a year with the stay. I think it was appropriate to enter the stay when there was some question whether the indictment might come down and overlap. Now that we have the second superseding indictment and they don't, I think it's now time to proceed to a trial in the civil case. There's 2 other factors, Your Honor, that the courts consider. That's the court's interest as well as the public's interest. This is on page 7 of your handout, Your Honor. And in both respects, the Indiana courts have said both of those parties, both the court and the public, are interested in the expeditious conclusion of cases. I think both of those factors weigh in with a 3-year-old case in favor of allowing NSBC to move forward in this matter. The next page, Your Honor, is factor 6. It's on page 8 of your handout. And that's the status of the criminal case. Back when the superseding indictment was against Mr. Whiteman only, there was a trial date set for November 16, of 2015, next month. I did look at the federal docket before coming out today, Your Honor, and one of the last entries on the federal docket was a status conference before Magistrate Judge Cherry. And in that docket entry, it's noted that the court is anticipating that the parties will be requesting a joint continuance of the current trial date. No doubt because additional defendants were alleged to have committed criminal conduct in the second superseding indictment. So we have a situation, Your Honor, where we don't have the likely outcome of the criminal case here in the near term, and this is going to be continued, which will result in a further continuance of our civil case if the stay isn't lifted. I think given the factors that the court has in front of it, given the new information that exists in the form of the second superseding indictment, Your Honor, I think it's appropriate at this time to lift the stay, allowing SPC to pursue what are serious claims in this case, as Your Honor knows from the prior PricewaterhouseCoopers report that we provided, and allow this case to be set for a trial so we can proceed on the merits. Thank you, Your Honor.
Okay.
Your Honor, on behalf of Mr. White and I'd point out that your order, which you entered in November 2014, states in number 4 that all discovery in this matter is stayed until further notice from the court or unless parties agree to additional discovery. Neither one has happened. And I point out as well, Judge, that we were here back in June this year, I believe. And I'm not quite sure to what extent the stay came up, but Your Honor did not, in his discretion, choose to lift the stay at that time. Now, plaintiff may make it seem like there's been an absolute halt brought to this case. It's simply not the case. They have seen third-party discovery from DeVita continuously for several months now. My understanding, deposition of Mark Bratman just took place in the last couple of weeks, if I'm not mistaken. At that time, plaintiff's counsel indicated that they wanted to pursue additional discovery from DeVita. That was something that was brought up as well. So it's not like this case has come to a halt. We're only looking to have the stay continue to the extent that the discovery would implicate Mr. Whiteman's Fifth Amendment rights, and that's really the core of the issue in this case at this point. As far as there being no overlap, the Third Amendment complaint and as well as the second superseding indictment, I would say, Judge, the superseding indictment is really nothing new. The allegations were lodged in the initial indictment, and there's overlap to the extent that allegations are made that Mr. Whiteman caused funds to be wrongfully drawn upon on lines of credit through the Centier Bank. Those are allegations that are made within both the Third Amendment complaint as well as the indictment. And one of those includes defendant Ashback. So he is, in this case, his involvement stems also from the criminal indictment as well. So it's the Fifth Amendment rights of Mr. Whiteman that are really an issue here. And put him in a position for even, I'm not sure how long it's going to be until the criminal trial is going to take place, but it's not going to be that long. But as the Fry case pointed out in our response brief, the court should not be put in a position, or put Mr. Whiteman in a position where he has to choose between losing a civil case or risking a criminal conviction. That's exactly what would happen here if the state is lifted. There's no indication that the plaintiff is seeking any discovery aside from the deposition of Mr. Whiteman. And that's too risky based on the prejudice to the defendants, all the defendants, quite frankly, involved in this case, Judge. Given the likelihood that the Fifth Amendment will be invoked should he sit for deposition, that will result in prejudice not just to Mr. Whiteman, but to all the defendants as well. I'm trying to formulate defenses to this matter. We're asking that the stay remain in place keep it in place. And so the government may have some other comments on the subject. Thank you.
Mr. Tober?
Your Honor. Your Honor, may I please report? I represent Dr. Ashback, a defendant in this lawsuit, Your Honor, and also very much involved in the indictment from the standpoint of the government talking to him and getting information from him. Your Honor, I don't think anything has changed in this case which would justify lifting the stay at this point in time, Your Honor. There's no question that there's been hours of deposition scheduled in this case and have been taken involving most of the doctors of the plaintiff, as well as expert witnesses, the DeVita witness, and my client, Dr. Ashback's deposition, Your Honor, was taken for approximately 5 or 5.5 or 6 hours one day at my office. And I'd like to hand, Your Honor, a portion of the transcript of that deposition. Your Honor, the portion that I'm handing you of the transcript is a question and answer interplay between Mr. Leckie and my client, which specifically addresses issues as to loans that he took out and sent to your bank that Mr. Whiteman was significantly involved in with regard to contacting the bank as Dr. Ashback's power of attorney and getting documentation for these loans. Your Honor, one of the central three themes through the complaint in this lawsuit is that Jack Whiteman controlled Dr. Ashback. Dr. Ashback was president of NSPC, Your Honor, at the time. That theme is still there, Your Honor, and it has been there since the beginning. There was approximately 10 or 11 pages of deposition, back and forth, questions and answers regarding the sent to your bank loans. Those sent to your bank loans, Your Honor, are a significant part of the indictment in the criminal case. And I would submit to the court, we haven't had an opportunity to question Mr. Whiteman regarding any of these loans because his deposition hasn't been taken in this case. And as I've indicated to the court all along, my client, Dr. Ashback, is substantially prejudiced if, in fact, the state is lifted without the opportunity to take the deposition of Mr. Whiteman, which hasn't taken place. We know that if his deposition is scheduled now, he's going to basically take the Fifth Amendment on all the questions that are answered to him, Your Honor, and rightfully so, he should. So we're in a position, Your Honor, that we're being sued by the plaintiff, but they want to proceed with the trial, and then we don't have an effective way to defend Mr. Ashback or Dr. Ashback because we haven't had an opportunity to interrogate Mr. Whiteman regarding any of these situations. And that, Your Honor, is prejudicial to my client for sure. If, in fact, Your Honor, Dr. Ashback in this censure bank matter was not central or very important to the indictment or the civil case, then why did Mr. Leckie take the time out and spend all the time during Dr. Ashback's deposition to question Dr. Ashback regarding it? He obviously deemed that it was reasonably calculated to lead to the discovery of admissible evidence in this case when he asked those questions, because as Your Honor knows, that's the standard of relevance as far as discovery under our trial rules. It would be very, very harmful, Your Honor, if in fact we weren't given the opportunity to question Mr. Whiteman and him give an explanation of what transpired in the censure bank loan transactions. And to lift the stay and require us to move forward without that testimony is an extreme prejudice to Dr. Ashback, believe me, Your Honor. We think, as the court has done on the last 2 or 3 occasions, that the stay should remain in effect. Crucial issues in this present civil litigations are going to be litigated in the criminal proceeding. And once again, if we don't have full access to all the witnesses and the parties, how can we go into court and try to defend this lawsuit and do it in an effective manner? It can't be done, Your Honor. So we would urge the court not to lift the stay, to deny the motion, let the criminal case proceed, and let's get on with the civil litigation once the criminal litigation has been concluded and we know where everyone stands, Your Honor. I would appreciate very much your consideration, Your Honor, with regard to this matter. Thank you.
Good afternoon, Your Honor. Carrie Connor on behalf of Mr. Whiteman and the other entities. Your Honor, I think it's very important to point out that for federal court purposes, the attempt by the plaintiffs to segregate or compartmentalize the actual allegations into the indictment as if they have no relationship to this case is really not an accurate reflection of federal law. As the court, I'm sure, is aware, in federal court we have the concept of relevant conduct. And that is that even when conduct is not actually charged in the indictment, when it is demonstratively a pattern of behavior or a similarity in allegations, the court can in fact consider that information. So though the allegations may not be specifically charged in the indictment as to the plaintiff's allegations, as that case begins to develop in federal court, the court will be asked to consider that conduct in terms of sentencing and other, if we get to sentencing, and even in terms of 404B evidence and for purposes of trial. Therefore, to suggest that somehow these are parallel allegations that have no intertwining is just actually not an accurate reflection of the law. In fact, based on concepts of relevant conduct, even uncharged conduct, even conduct that is outside the statute of limitations becomes relevant for federal court purposes. I would therefore reiterate that not only was lifting the stay create a situation where Mr. Whiteman could not defend himself against, as a defendant in this case, and could not also defend himself without potential ramifications on the civil side, but as Mr. Cullen has indicated, it creates a situation where the prejudice against Mr. Ashback deprives Dr. Ashback of the ability to seek a defense. It also deprives the entities at issues here of the information, whether incriminating or not, even exculpatory information that Mr. Whiteman has to offer in terms of the resolution of these cases. So, Your Honor, I think it's very, very important to emphasize that though the specific allegations may not be charged in the indictment, they are clearly inextricable from one another. They cannot be compartmentalized because under federal law, the concepts of relevant conduct would bring them into play at every aspect of the proceedings. We would ask the court to continue to stay as to the discovery regarding Mr. Whiteman, Your Honor, to allow ultimately for both the civil and the criminal case to be fairly adjudicated. As Mr. Leckie pointed out, it is likely that the November date is going to be continued. The court has to, by law, give the newly charged defendants at least 70 days from the date of their arraignments in order to prepare for trial. I do believe if the court were to extend this stay for another 6 months for a status hearing, we would have a much better idea at that point where we are with the criminal case, Your Honor. Thank you.
Are any of the witnesses or any of the alleged victims in the criminal case part of this case?
Dr. Ashcraft.
Okay. All right.
I'll be very brief, Your Honor. I've heard some arguments all around the room. And I might forgive Mr. Leckie for not recalling it, because I think it was his associate that argued before. But we've been before this court and had this matter reintroduced long after the indictment was actually filed in hand, and that was presented to the court, and there was argument had at that time. Your Honor, again, primarily standing up there, I represent two entities, MMDSA and Northwest Indiana Medical Property Partnership, which is a group of physicians that owns some land, some medical buildings. And Dr. Ashback is one of those partners, but two that we haven't heard are Dr. Michelle and Dr. Umapati, who have presumably no real relationship to all of this litigation, but their rights are impacted by what happens here today. Just as we've heard it, if Mr. Whiteman does not testify, their interests are put at substantial risk, either through exculpatory evidence before the entity, or I guess in a worst case scenario for Mr. Whiteman, something that he did outside of his authority as the partner that was representing the entity or acting presumably on behalf of the entity. At least that's what I understand the allegations to be. But those two gentlemen, they're not a part of this proceeding other than through the entity itself. And, if their rights are to be jeopardized by an inability to present testimony and receive evidence from Mr. Whiteman. It certainly seems like an unfair result. The practical import of all of this is, as we've heard, there will be no testimony in the near future from Mr. Whiteman, aside from what we all think, whether they're related or not. Certainly his counsel has made the conclusion that that testimony is very intrinsically related. And I think the deposition shows us that, in fact. We've now been able to put some pieces together, and that deposition that took place in April, as it turns out, shortly preceded a discussion between Dr. Ashback and the government in May. When those questions were asked, I remember being rather surprised in the room, because I had not heard anything about those transactions, didn't know that what they had to do with our case whatsoever. But as Your Honor reads the transcript, there was rather detailed knowledge that Mr. Leckie had concerning apparently information received from Sensier Bank. I presume that wasn't Dr. Ashback giving that information. I don't know how his clients obtained that information for him to engage in that inquiry. I can make a supposition, because when we were here before, I suppose that his client had something to do with speaking to the government and maybe making complaints. I don't know that to be the case, but I just know that asking that series of questions about transactions of which I knew nothing when we walked into that room certainly suggests that there is a broader umbrella here, and who knows what we know as we stand here. But what we do know is that my clients won't have the benefit of Mr. Whiteman's testimony to help them defend themselves.
Just a couple quick responses. I think everyone shared the position quite well. As to the questions in the deposition, perhaps I can lend some clarity to the question of what has happened here. I didn't have any prior knowledge of any of these factual matters that they came out in this deposition of Dr. Ashbach. There are no suppositions to be made here whatsoever. I was simply asking questions that I'll posit a good counsel should when answers start coming up about these other subjects. As it turns out, what we learned from this deposition is that the Sensier Bank transactions that involved the casino didn't have anything to do with this case. They weren't claims that we made in this case, Your Honor. They concern the personal accounts of Dr. Ashbach and apparently another doctor who's unrelated to NSPC. That's all led to the second proceeding indictment. And so, yes, discovery, you can follow the questions and the answers to see what comes up. But this is not, the subjects of these answers in Dr. Ashbach's deposition are not the subject of the claims that SPC has made, as it turns out. Of course, you have to ask the questions to look at the information to make that judgment. Your Honor, I think, as we look at the second superseding indictment and the third amendment claim, we see that these are unrelated claims. I appreciate Ms. Connor's remark about sentencing. We're not here to talk about sentencing. We're here to talk about the two separate trials that would take place. I think Mr. Tauber and Mr. Yaney, for their respective clients, are interested in having a deposition of Mr. Whiteman. They're concerned that he may plead the fifth. I'm not sure any of that changes after the criminal case is done. He may well still take the plea. He may well still plead the fifth in this civil case at a deposition, given the assertions of the factual evidence that PricewaterhouseCoopers has prepared in his report. So I'm not sure how waiting serves their client's interest to get Mr. Whiteman's deposition. We're all interested in that deposition. We're all interested in having this case tried on the merits. And SBC is particularly interested in that, Your Honor, if we ask for the statement.
Sure.
Your Honor, just to clarify, the questions that were asked Dr. Ashbeck during the deposition that he testified to, he related regarding the loans, did not include solely any loans that he used to try to pay casino debt off. They include loans that Mr. Ashbeck made to Mr. Whiteman for a business adventure, okay, for several $100,000. That was a big part of the Sensier Bank loans, and those loans are part of the criminal offense. There was a Century transaction about MSPC also directly that was a problem. So, I mean, it just isn't limited to the casino.
Well, the bank has lots of accounts. I mean, come on, let's be serious. Since your bank had a loan that extended to NSPC, it wasn't these transactions that dealt with Sincere Bank. That concerned Dr. Oshkosh's personal account. So to say, well, since your bank was involved, really doesn't tell us anything wrong. Since your bank that we know had lots of accounts that were separate transactions, we all know those facts.
Is Mr. Reichman the only deposition left in this case? Is there other discovery needs to be done?
We had a little follow-up concerning a couple of your clients, as I recall. There were two, one that was not completed, Dr. Ristotti, and as I recall, prior to the introduction of Dr. Ashbeck to the case, I think Dr. Artu was perhaps included for that. And I don't know if anything else is needed with them, but I know that Dr. Ristotti was not completed.
Yeah, I just tested my memory from about a year ago, but I think we had PricewaterhouseCoopers expert deposition scheduled or about to be scheduled at one time. So that was completed.
Was that done?
Not at PricewaterhouseCoopers. You took Byron Kennedy, but not the gentleman who prepared PricewaterhouseCoopers. PricewaterhouseCoopers deposition is still Mr. Whiteman's deposition would still be needed, and of course I think there was some written discovery that was sent to Mr. Whiteman that was stayed in preparation for that deposition. There may be a position of ours that still needs to be finished, but we have a little bit of work to ramp up and get completed for a trial. But from our perspective, Your Honor, for the plaintiff's case, we're ready to go once we have Mr. Whiteman's deposition.
So all discovery except for Mr. Whiteman's completed?
Your Honor, I wouldn't say that. From the defendant's perspective, there may be some additional depositions. Okay, so I don't want to...
Well, what I'm getting here is we can complete the other discovery and then we can have another status and see where we're at. If there's a lot of discovery left, I don't know what's left to complete. But
That would be fine.
when is this trial, the federal case, expected to go?
Your Honor, it's presently set for November 16th, but that will be continued. I
Right.
believe there's an arraignment on Wednesday.
And when do you, I know you really can't say, but
I don't know, but my guess is that probably it'll be set for something like February or March. They'll probably avoid the holidays and look for a date soon after that, meet the court's calendar.
so we should do
But that
a,
is a guess. That is a guess.
why don't we do a status right after the,
That's 2016.
maybe in February?
Wait a minute.
February?
Maybe not be able to...
Well, but at least maybe in February we'll know exactly when we got a trial date and okay. About February 17th.
That's fine, Your Honor.
Same time, in the afternoon?
That'd be great. Yeah, Your Honor.
Okay. All right, February 17th, it would be at 2 o'clock?
That'd be fine, man.
All right, and then we'll set for status then. The status to Mr. Whiteman remains, leave it in effect, and any other discovery conduct, I guess. All right, anything further?
Not for the plaintiff, Your Honor.
All right, thank you.
Thank you, Your Honor.
All rise.